I'm a solicitor specialising in wills, powers of attorney, trusts and probate. So I want to go back to our case study and explain to you where I fit in. So my job is to sit down and ask those really difficult questions that nobody really likes to answer. I want to know what you think will happen if you lose capacity or one of you or both of you dies, comparing that to what will actually happen, and then asking you what you want to happen and sitting down with you to try and make that happen. So if we start with capacity, lasting powers of attorney were introduced to enable you to choose people that you trust to make decisions on your behalf if the day comes when you can't make those decisions for yourself. They're legally binding, and there are two types so that you can pick different people to deal with the different aspects of your life. So how do they work? Well, we all sit down, put the paperwork together, and everybody signs, and then they get sent off to a special part of the Court of Protection who register them. They come back to you and then they're ready to go. So they can be passed on to doctors or banks as necessary, and any company is likely to want to take a copy, ID the attorneys, and then they'll take their directions straight from the attorneys. So who needs one? Well, the answer's very simple. We all do. So if we all need one, why doesn't everybody have one? Well, these are the common reasons I hear. We're married, so we already have next of kin. We own everything jointly, we wouldn't have a problem. We're too young, we'll worry about that later. Or we can make them ourselves, so why would we use Preston Reeves? Well, they all sound like quite good reasons, so let's now turn to each of them and see why that doesn't necessarily work. It doesn't matter who you are, if your name's not on an account and you don't have authority, you won't gain access. Powers of attorney are the only document that will continue to be effective even if somebody loses capacity. Next of kin don't actually have any legal authority. They're really just the people to contact if there's an accident and the people to talk to, but ultimately the decision will rest with the healthcare professionals unless you can produce a power of attorney to effectively step into the shoes of the patient and make those decisions. The local authority will often get involved if a person who lacks capacity needs medical care, and quite scarily, they often have a lot more influence than the family in deciding what care that person should receive and where they might live. So if we turn to our example of Tom and Steph, let's actually look at how accessible joint assets really are. So we know Tom's got a pension. That might be okay if Tom's okay, but if he loses capacity, how will Steph gain access, especially if we need to change where the pension's paid into? We know that they have joint savings, so that might be okay, but it really depends what they are and who holds them. If you have certificated shares, for example, if you need to sell or transfer those, you're going to need 2 signatures on those forms. Chattels, well, I was going to say that they're only worth 15,000, but perhaps we should come to you, Rupert, and find out. Maybe Tom and Steph might get a surprise and they might be worth a lot more. But imagine they are just 15,000. It doesn't release much cash, and it's probably the last thing that Tom and Steph would actually want to have to sell. They've got ISAs, as we know. These are individual accounts, so half could be locked. They've got shares in their trading company. Tom and Steph tell us that they've got approximately 50% each, so we know that half of the capital is already locked, and also the voting rights that go with those shares. Then we've got the properties. So what does it really mean if you own property jointly? Well, actually, if they did need to try and sell one of the houses and move to something more suitable, they're going to need 2 signatures on any contract for sale. Similarly, any rental agreement will need 2 signatures for it to be renewed, so rental income could stop coming in. And if that developer comes along to give them a good offer on the paddock, again, that developer will want 2 signatures. So what starts as quite a big estate is quickly becoming pretty inaccessible. Sadly, You can never be too young. Accidents happen at any age. It's often younger people who have more financial commitments. LPAs should be thought of as an insurance policy, something to have in the back pocket in case it's ever needed. So why think of them any differently to any other insurance? Imagine if somebody said to you, oh, I don't take out car insurance. I'll worry about that when I think I'm going to have an accident. It just wouldn't work, would it? Unlike other insurance policies, you're just paying a one-off fee rather than a yearly premium. So why use Creston Reeves? Well, it's not the form filling in that you're paying for, it's the advice and expertise that go with it. We've got plenty of experience in this area. We can tell you what works well and what doesn't. And sometimes it's easier if your lawyer asks your son to fill in a form than you do. So having listened to that, Tom and Steph think, yeah, we'll go ahead with powers of attorney. Now we need to look at their wills. So they tell me that the things that are really worrying them are inheritance tax. They want to know how much they'll have to pay and how they can reduce it. They want a bit of security for the survivor who might be left behind. Where they're going to live, will they have access to funds, will they have access to the company? And finally, their ultimate goal is to protect their children. So if we turn to inheritance tax, it's a very quick overview here, but in summary, it's charged at 40% on a person's estate, which includes the value of any lifetime gifts or transfers they've made in the 7 years before death. Certain exemptions and reliefs will apply. Anything passing to a spouse or civil partner or to a charity will be tax-free. Then any business and agricultural assets might qualify for relief. It's possible to claim up to 100% relief depending on various factors. In addition, each individual has what's called the nil rate band, which is the amount we can give away tax-free. And as Daniel's pointed out, that's currently £325,000. It's transferable between spouses and civil partners. In addition, there's now the residence nil rate band, which is specifically tied to your property. It's currently worth £175,000 and it's also transferable. But there are quite a few restrictions and exclusions that apply, so it's not as readily available as the nil rate band. So if we now apply that to our current case study, Tom and Steph, this is possibly before they've spoken to Lee, say to me, we just want to leave everything to each other, and then on the second death, we'll leave it down to the children, and the survivor will probably take the pension and sell the business so that they can focus on the children. So what we have here is no inheritance tax on the first death because everything passes tax-free, but we've also lost our business property relief in selling the shares in the company, and the estate's too valuable to get any of the residence nil rate band. So the only thing that will apply are the two nil rate bands. You can see we're looking at a tax bill of 1.376 million. So what can we do about it? And that's where Lee pipes up and says, does the survivor really need the pension? That's potentially a pot that if we can leave that untouched or bypass it, send it straight to the children, we could save £200,000 of inheritance tax straight away. We could also consider some lifetime gifting so that we can try and reduce the value of the combined estates, and Joe will explore this in more detail. What about the business? Well, Joe tells us that the shares in the company will qualify for inheritance tax relief at 100%, so long as the couple are still working and it's a trading company. So there wouldn't be any inheritance tax on the first death. And it might be okay if the survivor can carry on working for the rest of their life, but the rules could change, HMRC could change the rules, or the survivor might want to retire at some point, or they might have to retire at some point. So what can we do? One option might be to include a business asset trust in their wills. This would mean that instead of leaving all of the shares in the company to the surviving spouse would still retain their 50% of the shares, But the other 50% would pass inheritance tax-free into a trust. It would be a discretionary trust that the survivor could still benefit from, and so could the children, but until then, the shares remain in the control of the trustees. This could be very useful, especially if the hope is perhaps one day one or all of the children might get involved in the running of the company and they could inherit the shares one day, but right now they're just a bit too young. This might give them a chance to finish their education, settle down and prove themselves before the shares pass to them. Also, if the survivor does sell the business in their lifetime, then we'll have £1 million of cash sitting outside of the survivor's estate, sitting in this trust instead, which could be used for anyone's benefit. So if we now revisit the inheritance tax position, with just a little bit of advice there, Tom and Steph decide, okay, we'll leave the pension straight to the children. We like the idea of the business asset trust. We'll still leave everything else to the survivor, and the survivor could still sell the business. Well, you can see we've already managed to nearly halve the inheritance tax bill. And then probably we could look to Lee and ask whether we could take out some kind of insurance policy to cover the tax bill. But it's not all about tax. We need to think about the family dynamics. Tom's greatest concern is Ben. Ben doesn't belong to Steph, and although he trusts Steph and thinks Steph will do the right thing, there's just a niggling concern. Steph and Suze have never seen eye to eye, and he worries that one day there could be a big falling out if he's not around to be the peacekeeper. Ben could be overlooked. Steph points out that she loves Ben, but he does have another parent who he will inherit from one day, whereas Jess and Jake only have Steph and Tom. So how do we balance these interests? Well, one thing that might work well for Tom and Steph is a flexible life interest trust. This would involve splitting down their assets so that they each own half. Then, on the first death, the shares in the company that qualify for inheritance tax relief would still pass into the business asset trust, as we've discussed, but everything else from the first spouse would pass into a second trust specifically designed for the survivor. The survivor becomes the primary beneficiary, and they're entitled to receive all of the income from the assets. They can live in any property, but ultimately the capital is preserved for the remainder beneficiaries, who in this case would be the children. The trustees, however, have a bit of say, and they have the discretion to pay from the trust to any of the beneficiaries, the children or the survivor, if there's a good reason to do so. And when the survivor passes away, what assets are left in the trust will pass down to the remainder beneficiaries in accordance with the will of the first to die. So why might this work for Tom and Steph? Well, it might just give them the security they're looking for. It will mean that at least half of their estate will pass down to the next generation as planned, even if the survivor remarries, gets into financial difficulty, changes their will, goes into care and has to spend all of their money on care. The inheritance tax position is unchanged. It's the same as though the survivor inherits everything, so the tax is deferred until the second death. It's very flexible. It could be wound up at any time if it's not needed. And there are also capital gains tax benefits for ongoing estate planning. And one thing that might appeal to Tom and Steph, where they have a large estate, we're going to talk to Jo about some lifetime gifting, but as we know, you have to survive 7 years each time for gifts to fall outside of your estate. So it's a pretty long process. If you die before you've managed to complete that tax planning, what this does is allow the trustees access to half of those funds to carry on that onward gifting, even if the survivor loses capacity, which is something that you wouldn't be able to do if everything went to the survivor. But trusts aren't for everyone. Some people don't like the complexity of them, This sort of trust would have to be registered on the Trust Registration Service. It's not tax efficient if the couple are unmarried. Some people don't like the idea that the survivor doesn't own everything outright. And if there are mortgages, likely chances are they'd have to be repaid before those properties can pass into the trust. However, for Tom and Steph, those aren't really concerns for them, and the advantages outweigh the disadvantages. So in summary, we've managed to put some LPAs in place. We've almost halved the tax bill. We've put wills in place that cater for changing circumstances with an element of protection. And all of these things are going to give Tom and Steph the peace of mind that they've been looking for. And then Joe will chip in and see what else we can do.